se me oye. Por favor, buenas tardes. Vamos a empezar el acto.
Good afternoon. We're going to start in a minute.
¿Está encendido o no?
Is the system connected? Can you hear me?
Buenas tardes, empezamos.
Good afternoon. We're going to start the meeting.
Tomen asiento, por favor.
Could you please sit down because we're going to start the meeting in a minute.
We are going to start. ¿Vale? ¿Voy? ¿Vale? Good afternoon, ladies and gentlemen, dear friends. It is a great honor for me to present this event in which we are celebrating the 50th anniversary of IPRA-CINDER. Today is a special day where we are going to highlight not only the importance of the land registry for states and citizens, but also the usefulness of this international organization. Today's event commemorates these 50 years of exchanges and service. And it consists of the following parts. First of all, we will listen the welcome speech by Mr. Alfonso Candau, Secretary General of IPRA-CINDER. Then we will have the pleasure of listening to the representatives of Argentina, Puerto Rico, and Spain as founding countries of the CINDER. The inaugural session will be in charge of Mr. Jack Vos from the Cadastre of the Netherlands. And next, the roundtable moderated by Luisa Clode, President of ELRA, will take place. The topic to be discussed is the evolution of land registries over the last 50 years. And the speakers will be Mr. José Antonio Saavedra, del Instituto Peruano de Derecho Registral, del Perú. Mr. Ricardo Novoa, Dirección Nacional de Registros de Títulos, de la República Dominicana. And Mr. Sabentin Tunas, General Directorate of Land Registry and Cadastre in Turkey. Finally, we will view the screening of the commemorative video 50th anniversary, and then the closing ceremony. Without further delay, I give the word to Mr. Alfonso Candau.
Good afternoon. Thank you to everyone for coming here. Some of you from distant countries. It's very, very remarkable. It is a pleasure for us to meet today here in Brussels to celebrate our first 50 years. From November 20th to December 2nd, 1972, the first International Congress of our association was established and celebrated formally in Buenos Aires. The initiative for registers from different countries to come together began with the Institute of Registry Law and the Argentine Notarial University and the Registry for Real Estate in the city of Buenos Aires. Two observers of particular importance attended the first meeting, UNESCO and the Organization of American States. Tienen todos ustedes, you have a headphone for the translation at the link side of the seat. because of my English is very bad. On the first day of the Congress, the International Property Registry Association was established. Its founding members were the Institute for Registry and Notarial Law of Puerto Rico, the Institute for Registry Law of Argentina, and the Association of Registry of Spain. Dr. Edgardo Scotti was appointed Secretary General. Following the inauguration, representatives in attendance from the Argentine government, the Minister of Justice among them, initiates the working sessions, divided into 3 commissions. The results gathered from this commission were named the Buenos Aires Charter, that contained for the first time in registry law a series of declarations and recommendations that surprisingly maintain their validity without being altered or modified by the progress of new information technologies. At its core, this charter contained a summary of general tenets similar or coincidental, by means of which all the countries, whichever one was its registry system, configured the essential areas of the respective laws for a solution to identical legal problems. Quisiera evocar la memoria de todos aquellos que han colaborado con la asociación durante estos años y que ya no están.
I would like to evoke the memory of all those who have collaborated with us and are not here anymore. 50 years is not a long time for an institution, but it's an estimable period for the time of a human life. It is up to all of us to take up their legacy and to promote the task for those who come after them. It is impossible to list all the contributions that have been made so far, mainly at the 22 congresses held to date, which constitute the main scientific and personal meeting point. It is also well known that the enrichment of our different registers is due not only to the exchange and contrast of knowledge, but also, and not least, to the personal meetings that take place between us before, during, and after each Congress, where the members of each registry can meet. I apologize for not being able to mention individually all those who have contributed to the work of the association, but I cannot fail to mention and be grateful for the presence among us of Fernando Muñoz Cariñanos. He was present at the founding Congress in Buenos Aires and made a decisive intervention in the panel dedicated to what was then called the mechanization of the registry, or the automatization of the registry. As I said before, what I said then is applicable to the current reality of land registries. I'm going to limit myself to stating literally some of the conclusions reached there. You just have to replace the word mechanization by the word computerization. It was said that mechanization is a simple instrumental means that must always be subordinated to the substantive principles and essential purposes of the registration systems. The degree that mechanization needs to reach is moreover conditioned by the legal peculiarities and the geopolitical and socio-economic circumstances of each country. And it is recommended to the competent bodies in each country to study and implement modern techniques of rationalization and mechanization of work in land registers. Furthermore, and I continue to read literally the conclusions adopted at the time, it is not sufficient from the point of view of its legal value, the mere storage of the information on a medium such as a cybernetic medium, this was the word used in 1972, but the legal qualification activity of the registrar is indispensable. It continued to say that mechanization cannot limit the birth of new legal entities that must have access to the registry, and the access to the registered information should be facilitated by means of mechanized and updated auxiliary indexes of properties, land plots, and persons that allow it to be located, advising the use of microfilming, this was the state of the art in those years, and in general of any security procedure to facilitate, if necessary, the total or partial reconstruction of the registry without prejudice of the conservation of the old documents and books that must be archived. I will not go on to quote all the conclusions of this paper due to time constraints, but believe me, they were pioneering in the analysis of the paths that were to be followed universally in the following decades, and not just in the world of law. These ideas have been developed and adapted to the technological reality in the successive congresses of our organization, in many cases anticipating data processing techniques that are now commonplace in our contemporary society. I would also like to make a second exception by mentioning somebody by name, Rafael Arnaiz, who also made the effort to be here today. Rafael took over as Secretary General in 1996. He's largely responsible for the expansion of CINDER to many different countries. He organized the congresses in Marrakesh, 1998, Punta del Este in 2001, the conferences both in Moscow and Fortaleza. And as you know, more than 79 institutions from 58 countries of 5 continents are members of the organization, from Chile to Russia, from Chile to South Africa. And thank you, Khalid, for being here today, from Dubai to Canada. CINDER has maintained its political neutrality throughout the years, its only guide being the fidelity to its founding spirit, to be an independent, open, structured, and international organization with different bodies, both academic and professional, that in a way or another are related to the specialty of real estate registry law. The members have an aim, which is to increase communication in order to strengthen the bonds of union, as well as to promote and encourage the study of subjects and issues related to its object. This is how it has been so far, and it should continue to be. A third and final exception, CINDER publishes an electronic journal which is published by the South American delegation in Brazil, in the Instituto do Registro Imobiliário do Brasil, as they call it in Portuguese. Until the 80s, a journal on registry law was published, and in the new era, it is published in electronic format and in English. The scientific committee is composed of a group of professors from different countries and legal traditions, from Europe, like Germany, France, and the UK, from Australia and New Zealand, from Brazil, from Spain, as well as the lead economist of the World Bank, Klaus Denninger, in Washington. Klaus Denninger, who works at the World Bank. Issues have been published on the possibility of applying blockchain technology to land registries, on the institutional problem of organizing registries, a topic that was discussed at the Cartagena de Indias Congress. It's a question of whether to place the registry in the public sphere or in the private sector without overlooking the possibility of solutions that lie somewhere in between. Among the countries that form part of our organization, there are all sorts of options in this respect. Well, like I said, the journal is published by our Brazilian friends at the Institute of Real Estate Registries, and in particular to Sergio Giacomino, who is also with us today. We are proud to note the high scientific level of the journal, not just due to the quality of the authors of the papers and to Sergio's competence, not just from the point of view of his knowledge of registry law, but also because he has participated in many congresses and therefore he has incredible lucidity in highlighting the organizational aspects of real estate registries. This is why he has become an essential international reference point when it comes to determining how any registry reform should be carried out efficiently. For all these reasons, I want to thank you both. And then jumping 50 years in time to the last Congress, from the 16th to 18th May 2022, the speaker speaks Portuguese, and after 2 years of delay, this was organized in Portugal, in Porto. It was the 22nd International Congress on Registration Law. Some of you were there. The topics of the Congress were the following. Firstly, the land registry in the face of globalization. This theme analyzed matters relating to international organizations and cooperation networks between the different registry systems. As to sustainable development, the role of the land registry in the face of the challenges of the 21st century, economic and social consequences. This point includes the study of issues as diverse as georeferencing, the participation of the register in the elimination or reduction of social injustices, the fight against money laundering and organized crime, or the technological revolution in big data. I will never cease to thank the Portuguese colleagues for their work in organizing the event. Hoping for the end of a pandemic that seemed to drag on indefinitely, and with the help of the Institute of Registries and Notaries and the Association of Registrars, they managed to have the support of the authorities in order to organize, to hold a Congress that can unequivocally be described as the largest in our short history. The speaker goes back to Spanish, and immediately to the present, and following an unwritten custom, an international custom we could say, of crossing an ocean every Congress, the next one will be, God willing, in Costa Rica in 2024. This was unanimously agreed in Porto, Portugal, thanks to our Costa Rican colleagues for having taken on a task which, although very exciting, carries with it a significant burden of worries and work. We look forward to the academic content of the Congress and to enjoying the beauties of that country, pure life, as they say, pura vida in Spanish, whose nature can rightly be described as a paradise. I'll see you there. Thank you very much. Obrigado.
Thank you, Mr. Candau. As I said before, now we are going to listen to the words of the representatives of the country, the fundating countries. First of all, Argentina. We are going to view a video sent by Mr. Sebastián Cosola, and later on, Mrs. Zulma Doda will talk to us.
Muy buenas tardes a todos.
A very good afternoon to you all. I want to thank all the participants for having come to the event that commemorates the 50th anniversary of CINDER. According to the charter that was signed by the founding countries in Buenos Aires in December 1972. CINDER is a very prestigious organization at an international level and a completely necessary body. And we've been growing just as much as property law when it comes to publishing papers, to developing new ways of thinking, new schools of thought. Because what this is about at the end of the day is to have a property law based on principles and then consolidate the role of our institutions, our registries, to basically facilitate the communication between citizens and the state in all our countries. As the director of my university in Argentina, and within that university, the Institute of Registry Law, one of the founders of CINDER, it's an honor and a pleasure for me to speak to you, to address these words to you during this very important event that you are commemorating in Belgium, in the city of Brussels, hoping to see you in the flesh very soon in Argentina, so that we can speak about new schools of thought, we can develop new philosophies, and we can celebrate the fraternity between countries, nations, and hopefully we can develop a solid basis that will manage to bring our nations even closer from the point of view of property law, nations that will be together forever. In representation of my university, the director of the institute is in the room, Zulma Doda, and probably she will speak after this video and will address some warm words to all the participants. Without further ado, I'll send my regards from Argentina, and like I said, hopefully I'll see you in the flesh in Argentina very, very soon. Thank you.
Buenas tardes a todos.
Good afternoon. It is a great pleasure and a great honor for my institute in Argentina to speak here as one of the founding members of CIDER. And we've participated in every CINDER Congress from the starting one in Buenos Aires in 1972. At the time, 50 years ago, our institute and the Buenos Aires Registry invited many experts on registry law for the first conference on the matter that was organized from the 27th of November to the 2nd of December 1972. The objective of the conference was to discuss topics of mutual interest. And at the time, one of the main issues of the meeting was to establish a permanent body with the idea of organizing frequent meetings, regular meetings, where we could discuss and exchange information between anyone who works in property law, registries. The chair was the chair of the Institute and the Registry of Buenos Aires, Mr. Edgardo Scotti. In his opening words, he underlined that Argentina had a significant precedent, different national meetings of directors of property registries that had been meeting every year for 20 years already. And they had been discussing matters of property law, registry law in several workshops and then published in several papers drafted by the Institute. The Buenos Aires Charter, the declaration that was signed during that first meeting, takes into account that comparative law in our field allows for comparison of basic principles, and we need to use terms that, even though are not reflected as such in legislation, will be accepted by the different schools of thought. That was confirmed by the different conferences that worked in order to draft a dictionary that would define the terms that we use in our field in all our different countries. The Spanish delegation made a very significant contribution during the event in Buenos Aires. They contributed to preparing a document that was suggested at the initiative of Argentina. The name Carta de Buenos Aires in Spanish, the Buenos Aires Charter, was suggested by the Spanish delegation, and it was voted by all other delegations. The document, amongst other things, recognized the independence of registry law, defined its main principles, and established that the main goals were to have more legal certainty, facilitate mobility, to guarantee compliance of the rights of citizens, specifying that registries are the bodies where real rights have to be guaranteed, as well as all the measures that are necessary for those assets to be available. The Charter concluded by saying that the appropriate means in order to achieve good work at the registries would be that any document that has to be registered will be registered by specialized staff, experts that will assess with a critical view the content, the facts, the business transactions, the ownership, everything that is required in order to have the necessary result. And that any document that has to be registered will be formalized officially in a document that will guarantee legitimacy and accuracy of the document in law. And that charter also went on saying that those deeds need to be obviously assessed by the registrar. The registrar has a very important function, a very important duty. So the registrar has both rights and duties, developing their tasks and assessing the legality of each document. Over the past 50 years, CINDER carried out those duties established in 1972 and therefore organized several conferences, several congresses in order to exchange information as to the legislation in each of our countries on many interesting topics. Some of them we're still discussing, other topics were new because of new rights that have to be documented and registered. So over time we studied different things like, for example, the protection of property law, the legality of documents, the legality of court decisions, the weak points and strong points of different registry systems, of document registration, the right to privacy, the day-to-day work of registries, the first registration of a document, the relationship between the registry and the cadastre, urban planning, and many other topics. At the present time, registries have joined a very popular current in today's world. And they find in CINDER a platform where they can discuss digitalization, that new trend. Nevertheless, CINDER does not deal with technology for the first time. Just like the Secretary General mentioned in the opening words, in 1972 the first technological seed was planted. And on top of that, in 1989, during the Congress that was organized in Argentina, the second topic of the Congress analyzed computers and its relationship with legal certainty and the responsibilities and liability of registrars. And at the time, it was said that IT technologies make a significant contribution to the work of registries, but it is essential that the legal certainty will have priority, trying to find the perfect balance. At CINDER, we guarantee the goals that were included in the Buenos Aires Charter, disseminating information about our field and trying to organize seminars, workshops, and meetings, and trying to foster the membership of new members that can represent a huge diversity of institutes and experts. So our institute in Argentina from 2006 organizes international workshops on registry law with the contribution of experts from other countries, joining forces and making everyone stronger. Carlos Paz was the place where the first of these workshops was organized. And it was said at the time that whatever system of registry you use, legal certainty in property law needs two elements. Firstly, the possibility to register legal and official documents, and secondly, having an efficient system, efficiency. So basically, this is what we could call preventive legal efficiency. This is what our registries need to achieve by being able to ascertain the author of the document, the content of the document. The first international workshop that we organized at our institute in Argentina ratified the Charter of Buenos Aires, considering that it is necessary to keep the same principles that inspired the establishment of CINDER. Our organization does not represent just one group of registrars or notaries or lawyers or judges. No, we include anyone and everyone who carries out research, publishes papers on property law or registry law, trying to have the most inclusive point of view. We are convinced that anyone who works in registry law, regardless of the discipline they're working, they have a contribution to make in order to guarantee the legality and officiality of documents that they register via the assessment of documents. This is the process that makes it possible for us to guarantee the legality of documents to citizens. And I would like to end my brief words by thanking everyone that has contributed to improving this organization. Thank you to everyone that attended conferences, workshops, because all of you make our organization stronger and bigger, that was created in 1972 in Buenos Aires.
Thank you very much, Mrs. Doda. Now we are going to listen to Ismael Molina from Puerto Rico. Thank you.
Muy buenas tardes. Un caluroso.
Good afternoon, everyone. My greetings from Puerto Rico, which is really warmer than here, but I'm very happy to be here today in this nice city. It's my first time in Brussels. It's a pleasure for us, for Puerto Rico, and for myself to be able to be here today. We were one of the founding members of this institution, and this means a lot for us. Puerto Rico has learned a lot thanks to this organization. We have learned about different registry law topics. We have been deepening in our system, in all the systems, and we have managed to have a more efficient system in our country thanks to this. We want to have an efficient system which provides everything we expect from it. In 1972, when CINDER was founded in Puerto Rico, we were still under 1883 Spanish law. When CINDER was founded, we had this charter of Buenos Aires, but 5 years later we have the Charter of Puerto Rico because we were the ones to host the third Congress of CINDER in San Juan. And Puerto Rico Charter was dealing with something very important for our law. And thanks to that, we managed to have our first mortgage law, which was the Act 198 from the 8th of August 1979. So 7 years have passed since CINDER had been founded, and we were still under the Spanish law. But then we created our new Puerto Rican law, our first law on the topic. And we managed to do two things at that time. First of all, something which was essential. We managed to acquire different principles of registry law, which had already been mentioned in CINDER in 1977. We learned about it, and we absorbed all those principles. And these principles are the basis, they are the key elements in order to understand what happens, because we cannot just have a law. We need to have some principles around the law. And when we had our Congress in Puerto Rico, we talked about these principles. But we talked about movable rights. A couple of years later, we created our mortgage law, and we also included movable rights, but our priority was property right, land state rights. And although these principles were applicable to something else, we could also use them because they had an impact in our law, because we tried to embed them somehow in our law. For instance, I'm talking here about qualification of the registrar. They have to be professionals, and they have to have a degree in law when they were qualifying notary documents, judiciary documents, administrative documents. they had to apply the principle of legality in order to say these transfers, whether they could be included in the registry or not. And once everything is an entry in the registry, which is the effect? Because we know what happens when something is included in the registry. First of all, this legal deed becomes certain. This is something that comes from somewhere else. It comes from an administrative place or a notary or a judiciary system, but it goes to the registry. And once it's there, there is a publicity which is implicit because it is then an effect for third parties, thanks to this publicity. Because we know that whatever is in the registry, we know it's something valid, it's something correct, it's right, because it has already been validated by someone else, and this someone else is a professional. So there is an important weight for this entry. And even if we have to go behind court, this is something which prevails because this is valid. And all these principles, the hierarchy principle, the consecutive nature, the order of transactions, the speciality principle, because we have to identify the good in such a way that there is no doubt that we are talking just about one's place, one good. There is no way to doubt between one or the one close to it. There is a certainty to make sure what are we including in our registry. And all these topics, whether thanks to this 1977 Congress in Puerto Rico, we talked about all of this. And thanks to hosting this third Congress, we managed to learn all that. There is something else important which also was included in our law. We created the body of registrars in Puerto Rico. And this is the only institution where all its members are registrars and they work in that field. Sometime later, our institutions have changed and some names have changed, but then, thanks to this new organization, this new body of registrars, and thanks to this law, we managed to keep going. And this is very important for us. On the 18th Congress of CINDER, which took place in Amsterdam, we ratified the representative character of this body in Puerto Rico, as this body became the representative of Puerto Rico at CINDER. This became the only institution where all the members are registrars. And this is really important because we had a group of professionals and we managed to maintain all the principles in CINDER. And I think that the best person in order to communicate and to research about law and registry law is this person, this registrar, because they have this power, because they have this legality principle which is linked to them, because they have been studying, they are professionals, they are the ones who know how to validate or qualify the documents, they have some norms to follow, which are stated by law. And all this was initially adopted in 1977 in Puerto Rico Charter. So whenever they have different facts, they have to validate, to check and validate, and then they have to decide and to apply law and qualify this document. So registrars, what they do is they apply the law to specific cases. For the first time we talk about that, it was in our Congress, and as I said, we managed to include this in our law. Now we have another law, which is called the Real Estate Law, which dates from 2015. It went into force in March 2016. And in this new law, we include all these register principles. This law acknowledges as well the registrar organization, which is now a professional college, the Professional College Institution of Registrars in Puerto Rico. It's not compulsory to be a member of this body, of these institutions, but in any case, all the active registrars, they accepted to join it, and they are members of this institution. They have joined it. Even if it's not mandatory to be a member of the Registrars Association, we all prefer to be there, to be a member, to apply law and follow all these principles within this framework. We have had very hard times in 2017. There were 2 natural disasters, and there was a difference of 15 days from one to the other, so this had an important impact in our work. But nevertheless, Puerto Rico managed to keep working, and the registry kept working, and as fast as we could, we were able to build everything, to create our institutions, to keep working, and to keep providing essential services to citizens. We wanted to make sure that users could be able to present their documents and they could receive their certificates, and things could keep going. Of course, there was some limitations at the time due to the issues in the infrastructures because of the hurricanes, but we managed to keep working. Afterwards, the COVID pandemic appeared, and it has affected everyone, not just Puerto Rico. So we also had to take some provisionary measures and to be able to keep guaranteeing service to citizens, how to keep working, how to prepare certifications, etc., etc. But we kept working. For some time we were working online at home. We received some computers and some equipment from the Justice Department in order to keep going. Little by little, we managed to go back to our office. And now we are completely operational. I think that there is just one registrar in Puerto Rico who still uses the laptop, and this is me, it's myself. I prefer to keep working in my laptop. When everybody went back to the office and stopped working online home, everyone had to give their laptop back, but I prefer to keep it. So in case I have to do something when I'm home, I can do it because I'm an official registrar and I work 24 hours, 7 days per week. I'm always a registrar. And I'm sometimes just thinking about things that I left at the office, and I keep working non-stop. But I wanted to talk about this experience that we have had thanks to CINDER. Puerto Rico was one of the 3 founders. Think about 1972. I was 10 years old, so I can't remember CINDER. But I have learned what CINDER meant, and I'm so proud. I'm so happy to be part of this, because there were only 3 countries, and we were one of those countries. And we have been active all the time. We are always trying to communicate, to cooperate with others, and we are also very keen on preserving one of the main principles of CINDER, which is the continuous research and development of registry law. Because registry law keeps moving. Modernization obliges us to adapt. Natural disasters also oblige us to shift and to modify and to adapt, and pandemic was the same. So we always adapt ourselves, but we maintain our principles. We keep communicating and we keep researching and learning. I am very proud of this. And I was so happy when I saw our colleague Anais. I want to apologize here because I'm really moved here, but I was in '98 in Morocco for the first time, and this Congress was organized by our colleague here, so I feel very happy to be here with you today. I'm very emotional to be here with you again. Alfonso is also here. We have known each other for so long, and Eduardo Martinez is also an old friend. He has been in Puerto Rico several times. Nicolás Nogueroles, he was so important for Puerto Rico in different occasions. When CINDER hosted the Congress in Amsterdam, when we had this ratification of the Registrars or Association of Puerto Rico, he was the representative bona fide of Puerto Rico before CINDER. So thanks to all of you. I wish you a lovely day. And once again, thank you very much for being members and part of this institution. Thank you.
Muchas gracias, Dr. Molina, por sus palabras.
Thank you very much, Dr. Molina, for your words and for being so clear and for talking about what CINDER means and all this means for us. It's a pleasure for me to be able to give the floor to Doña María Emilia Adán. Please.
Secretario General del CINDER, Presidenta de ELRA, de la Asociación Europea de Registrados.
Chair of ELRA, registrars, colleagues, dear members of CINDER, ladies and gentlemen. Today is a day of celebration for all of us. For all of us who are members of this big family created by the registry institutions. Not all institutions can be so proud of achieving 50 years, and not all of them can be so proud of the same track that we have, because we are doing things and we are doing things in shape properly, growing every year. And I'm not just talking about the number of members that we have. It's that we are reaching different proposals, topics, goals, and every time we are more ambitious. It's a special occasion, and I think we all should be very proud of where we are right now and also think about how we got here. But we also have to be very happy and think, what can we reach? Because CINDER was created 50 years ago. It's a forum. We exchange ideas and opinions here, and we have different principles which join us, which are registers. But this is not something static. We are not just reviewing our work and the things we have been doing till now. We are not just here to talk about how well we do things. This is a vivid and dynamic place, and different approaches are here, and we have different points of view. We see societies differently, and we just try to make our institutions more useful and more efficient. Because CINDER is present in all 5 continents. CINDER is very proud of having had different observers. UNESCO, the Organization of American States. In CINDER, in its congresses, in its journals, we have had hundreds of comments of different topics, and we are always evolving with the society. We are just trying to see which are the real needs and how we could support this. Our congresses and our meeting points, this is where we exchange ideas and meet people, and we have had hundreds of participants, And every 2 years we have conclusions, and they are really useful. We all read them because they are a reference at global level in order to see how to proceed, what should be the future of registries, because the registers are the guardians of liberties and freedom and security. And there's something we can talk about here. It's legal security, because this is important, because this is linked to our fundamental rights and the ones of our citizens. So we are also very proud in our registry association in Spain as co-founders of CINDER is the huge diversity of understanding our work. This is really enriching. And different persons think differently, and they think about which is the role and what can we do, because we are in different cultures and in different frameworks, and we try to always serve citizens regardless where they come from, regardless how they are. And this can be seen throughout time. CINDER has different organizations which are composed by many people. And in all these 50 years, everyone has been evolving, has been developing in a different way. And in all these 50 years, everything has evolved really quickly. For instance, we can think about different congresses that we have had. We were in Argentina in 1970s, in Buenos Aires in 1972, in Mexico in the 80s, and the Congress in 1982, in Morocco in the 90s, in Marrakesh in 1998, in Russia in the year 2000, Moscow 2003, in the Arab Emirates in the second debate of this time in Dubai in 2016, in Portugal in our current decade, in Porto in 2022. So which is the common link with all these contexts, all these cultures? Because these places have been the meeting place for all of us, the registry family. And the thing is that we are all proud to be there, and we are all proud of what we do, and we want to share everything with the society, and we want to create secure environments so that the economic and social development of our nations can be improved. So we evolve with the time, and this is one of our main assets, and we can be proud of that. And in this case, Spain, I'm representing Spain here, has been co-founder of CINDER and has also hosted the international event in 4 occasions, 74, 84, 92, and 2008 in Valencia, in my own city. And also in different moments of the institutional and political story, CINDER was there. So I just want to thank all the registrars who have represented my organization. Different speakers have already mentioned some of them, so I would like to thank specifically a Fernando Muñoz Cariñanos, a Rafael Arnaiz, Nicolás Nogueroles, but also to all those who are working today in order to make all this real. And we cannot forget all the people who cooperate in the Registrars Association in Spain, because they also support everything which means CINDER. So thanks to all our collaborators, thanks to everyone who makes all this possible. We are talking about diversity, about different ways of thinking, different cultures, different historical moments. But there's just one idea that goes beyond all of this and keeps us in the good track. And that's what I try to explain. And it is that we are a key element for legal certainty and security. We, thanks to our work, contribute to have a better world, a more human society. Gomezindo D'Artkarate said that in Spain, the institutional registry fosters the social and economic development of peoples. Our goal is not just to guarantee what happens. We are providing a public service, and we want to make sure this has the highest quality. The quality which ensures that this service is for citizens. And technology cannot just make us lose our point of view. We need to be close to citizens. We need to have our offices. And I'm not just talking about people. We have different teams, coordinating teams. We are all close to the citizens, and we cannot forget that. And we also have to think about public administration, because we try to serve them, to help them as much as we can so that they can implement quality policies. Policies which allow us to be in the right place at the right moment. And we want citizens to trust our institution. They have to see us as an ally. We have managed to achieve different goals throughout all these years. We cannot just talk about real estate development, about access to credit, about reducing conflicts at real estate level, but we can also talk about other things, because we are fighting against money laundering, organized crime. And this makes us someone you can trust. We work together with our policy forces, with different enforcement agencies, and thanks to that, we create trust. So thanks to all of this, we can be here today celebrating this. So thank you so much. And thanks to you, and thanks to all of your teams and all of the people who have not been able to be here today with us, but they are also a key element for us. We are not just talking about goods, we are talking about people, and thanks to people, we are here today. We are assuming their legacy, and this is important. Thank you very much.
Muchas gracias. As I said before,
Thank you very much.
the opening session is charged to Mr. Jack Boss, who is a legal practitioner with a special interest for IT and international developments. He holds a law degree from the University of Groningen and studied law and IT at the same university. He has been a civil law notary for 5 years and continued his professional career as land registrar at Cadastre. He has delivered several publications and presentations, both on national and international level, and is guest lecturer at various universities in the Netherlands. He is representing Cadastre in the European Land Registry Association and has been participating in the IPRA-CINDER conference since 2010 and has organized various sessions at World Bank's Land and Property Conference. Please, Mr.
Thank you very much, ladies and gentlemen. Thank you. Dear Secretary General of IPRA-CINDER, dear Alfonso, dear President of ELRA, dear Luisa, dear colleagues and friends, both online and attending this commemorative event here in Brussels. Here we are today, 50 years of Congress. 50 years of existence and 22 congresses later on. And even of the greater importance, we are promoting the study of property registration law and spreading knowledge since 1972. I think this is a great achievement. And for that, I would like you to ask you to give a big round of applause to yourself, because all the work you have done in the context of IPRA-CINDER, and of course for IPRA-CINDER as our International Association of Property Registries. As the President of the Collegia already said, without the members of IPRA-CINDER, there is no IPRA-CINDER. So I would say congratulations. So ladies and gentlemen, I'm honored to be standing here today on such a momentous occasion and to speak to you about property rights in the world. And for this, it is important to ask the question, why do we need a land registration system? It seems so obvious, and it seems essential, indispensable. But on the other hand, it isn't so obvious in all countries in the world, and certainly not at this moment in time. The importance of property rights and land registration in these rights may be concluded as follows, and it's on the screen. A land registry is a governmental-run system for recording information about land ownership and property rights. It is important because it provides a reliable and official record of who owns a piece of land and can be used to determine the legal rights and obligations associated with that land. This information is used for a variety of purposes, such as settling disputes, determining property taxes, and facilitating the buying and selling of real estate. And in addition, a land registry can help to prevent fraud and ensure the security of property ownership. Overall, a land registry is an important tool for protecting the rights of property owners and ensuring the efficient functioning of the real estate market. One might just say that land registration affects us all. It is the process of recording and maintaining a formal and official record of land ownership and property rights, and it is a crucial aspect of any society. And such a record is essential to ensure the security of property rights and property ownership and the efficient functioning of the real estate market. But even broader than only the real estate market, it affects or supports, in a positive way of speaking, the whole economy of a country. It protects, supports, and partly establishes the rule of law. But please remember this description about the importance of land registration on this slide, as I will come back to this at the end of my speech. So there's a teaser. Land registries are of paramount importance worldwide. And since a lot of things have happened in the world in recent years, the importance of land registration becomes even more trivial. I just mentioned the economical crisis caused by a combination of factors, including the sale of large amounts of high-risk mortgages to investors, but also the environmental disasters due to the climate change, the civil or tribal wars spread all over the world, and quite recently, and more specific, the war Russia started in Ukraine. The ongoing land registration processes in Ukraine came to an abrupt halt. Servers and documents had to be protected against the aggressor, and some of these servers and databases are brought to other countries. And even large private companies, for instance Microsoft, offered their help and services. Let us hope Ukraine is able to push back Russia as soon as possible. And when this happens, the reconstruction of Ukraine becomes a top priority for the country itself. And for us, as registrars and experts in the field of land registration, we should be able to help our colleagues in Ukraine where and when possible. Land registration will be one of the pillars to help reconstruct buildings and dwellings and the corresponding property rights in Ukraine. Talking about property rights and land registry systems in the world and the role IPRA-CINDER is playing in that perspective, I will divide the topic into three parts. First, I will look back, moving back to the topics that we have been discussing during the 22 IPRA-CINDER conferences we celebrated since 1972. And then I will describe the current state of play and mention some of the challenges and issues we have to deal with at this moment. And finally, I will address the future of land registries, trying to look into the future. But just as you, I do not have a crystal ball, although I guess that part of the future is already in use by many of us. So future will be full of uncertainties and challenges, which may create interesting times, and on the other hand, it will keep us with our feet on the ground. But just because of those uncertainties and surprises, please keep in mind the description of the importance of land registration as I just presented in a world full of digital means. The association's origin dates back to December 2nd, 1972, when IPRA-CINDER's Articles of Incorporation were signed in Buenos Aires, Argentina. And ever since, the organization has been encouraging institutions to share their knowledge of registration law with other institutions all over the world. The goal of IPRA-CINDER is, as we all know, to promote knowledge of and conduct research into registration law. But IPRA-CINDER also acts as an intercommunication hub and an office where members can exchange books, journals, and other publications concerning law, technology, and registry organizations. And last but not least, IPRA-CINDER publishes an international journal which makes the resulting studies and any research concerning registration law available to others. I would need far too much time to try to mention the rich collection of conclusions that have been officially approved at the end of each of these 22 congresses. Nevertheless, it may be of interest to mention just some of the conclusions harvested during these congresses. I will try to keep it short, because it's quite a list. But it's a fact that every time the turnout has been very important, not only because of the number of participants from various countries attending, but also and especially because of the liveliness and participation in the debates. And these conferences were not only attended by registrars, but we also welcomed notaries and licensed conveyancers, judges, surveyors, and academics from all over the world. The most important contribution to this first Congress has consisted of the Buenos Aires Charter that has already been mentioned a few times today. It's a summary of the general statement that are similar or simple coincident by means of which in all countries, whatever their registration system, personal or real folio, the essential lines of the respective systems for the solution of identical legal problems are configured. In Madrid, over 500 attendees from 34 countries jointly discussed the principles and legislative development of the national registries, where in San Juan, Puerto Rico in 1977, amongst else, the rights that can be registered in the various registry systems were discussed, as well as the matter of real estate transfers of residents abroad. And this topic of migration and cross-border transactions would later on be addressed in some of the consecutive congresses as well. In Mexico, 1980, one of the commissions dealt with the topic of real estate registry and cadastre, which still is a topic that concerns many countries. Although registrars and surveyors are working in close cooperation more and more in many countries, the current technological state of play enables linking and exchanging data between land registries and cadastres, if implemented, better and better. In 1982, in Rome, the participants focused on the publicity of real estate complexes, which are characterized by the existence of a plurality of properties connected to each other through common elements of services. And even today, this still is a very actual topic as well, since more and more dwellings consist of a right in rem in a complex, sometimes due to lack of space or territory. Moving back to Spain, in 1984, the Congress concerned the topic of registration of the limitations of public law to the right of property and assets in the public domain and the right of superficies. In 1992, in Torremolinos, the principles of free movement of capital and the freedom of establishment and provision of services in addition to the freedom of movement of people were on the agenda. It was concluded that the role of real estate registries is considered fundamental within the spectrum of capital movement derived from cross-border real estate traffic and mortgage credit. In 1996, IPRA-CINDER welcomed its members in Lisbon. One of the topics covered was the first registration in the legal registers. And in Marrakesh, real estate registration as a development tool was on the agenda. 9 new institutions became members of IPRA-CINDER, and the CINDER regulations were modified. And since then, representatives of the administrations were able to join CINDER. In 2001, in Uruguay, the registry publicity and the right to privacy was amongst other topics discussed during this conference. And again, we meet a topic that still today is a serious topic to be discussed in many countries, including mine. Another topic that still is of importance was the continuation of the work on the formation of the Dictionary of Land Registry Terms, which in Europe is embraced some years later by ELRA, during ELRA's consecutive IMOLA projects. And this work is still going on in order to service European citizens and professionals in the real estate sector. The conference in Fortaleza in Brazil was convened to respond to problems that society has, a congress that tried to see the registry profession from the different perspectives, with 400 congressmen from all over the world participating. In 2010, the congress was hosted by the Peruvian colleagues in Lima, Peru, where part of the conclusion was that the lack of security in property ownership also hinders the exercise of citizens' social and political rights. And 2 years later, the Congress traveled to the Netherlands, my home country, where Nicolas Nocaroles focused his speech on new technologies, electronic registration and cross-border operations. The reform of the statutes of our organization was approved in Amsterdam. And during this Congress, the topics discussed were on foreclosures and new technologies, a topic that ever since has been on the agenda. Our Secretary General back then, at that time, stated that new technologies and those who represent them are a good helper for the registry, but decisions about the legal system should not be left in their hands. Otherwise, the computer program would prevail over the right, the auxiliary over substantive. And I could not agree more. It even seems to become more and more important, as we will see later in the future part of my speech. In Chile, 400 experts from 50 countries came together in Santiago discussing the organization of registries and the registry function in the face of new challenges. And again, the collaboration of land registries with the cadastral system was concluded to be important. But it was concluded that the registry and cadastre have different origins, purposes, and functions. The second topic, concerning real estate fraud and property registration, is also still an actual topic in many countries. And then came Dubai, the Congress with 4 official languages, amongst them Arabic. Over 450 participants from almost 60 countries from the 5 continents debated on the creation, the use, and limitations of land registry data, which again is still an important topic today. Another topic concerned smart contracts in a sustainable city using new technologies. In Cartagena de Indias, the topics, as in all Congress, were of interest to all the registries in the world. The United Nations Sustainable Development Goals were addressed. A specific topic was the reorganization of property in peace processes and the reform of property records. And again, we saw participants from the 5 continents, this time more than 60 countries, and in total 670 participants. And finally, last year in Porto, at the 22nd Congress, we had more than 500 participants discussing globalization, and to be more precise, the legal instruments of standardization, unification, and harmonization of law, and their impact on land registration. And it is important to note, in order to automize, you first need to standardize, and you need to digitize before you can automize. The opening theme was the international migration and its reflection in the registry activity. The prevention of money laundering and terrorist financing were also addressed. And again, we welcomed new countries as members of our beautiful organization. Moving to the second part of my speech, talking about the present. I already mentioned fraud prevention and detection as topics on the agenda of several congresses. And I also mentioned that fraud still is an actual topic. It still happens, and it can happen in various ways. It may also involve laundering money, identity theft, or other forms of illegal activities such as tax evasion. Depending on the content of the land registry and the role of the registrar in the real estate conveyancing chain, the registrar has either a very specific and active role in the prevention of fraud, for instance in Spain, in whatever form, or has no role in that matter at all, as is the case in the Netherlands. And then, as a true continuum, there are systems where the registrar's role is somewhere in between. And in all cases, there is or should be somehow a role for the land registrar, as real estate is a popular way to invest or launder criminal money. And adjacent to fraud, this also seems to be the case when it concerns the freezing of assets of people that are put on a sanctions list. The role of the registrar is of the utmost importance. It has been concluded that freezing of assets in practice is very complex due to the use of offshore entities, but also because of sometimes poor quality or the lack of the identifying data regarding the persons concerned. Mentioning the date and place of birth next to the full name of the persons concerned would already be of help. Identifying a person of interest on the basis of just a name seems insufficient and not free of risk of selecting the wrong person coincidentally bearing the same name. Through IPRA-CINDER, we have exchanged and built on fraud cases and realized mutual assistance. This enables us to create synergies across borders and supports a common understanding of the biggest risks concerning real estate fraud and money laundering. Digitalization presents opportunity and challenge alike. An ever-growing number of land registries has digitalized the documents, the deeds, underpinning the updating of the land register. And in some cases, the digitalization is work in progress or is planned to be done. In other cases, digitalization has been followed by automizing certain processes in the land registry activities. As is the case in many topics during IPRA-CINDER congresses, information and best practices have been exchanged, always with the respect to the state of play of its members. All countries, whatever their registration system, personal or real folio, have their own state of play and their own technological solution, and therefore IPRA-CINDER only configures essential lines of the respective systems for the solution of identical legal problems. I already cited a very important conclusion addressed by Nicolas Nocarolles, not to leave decisions about the legal system in the hands of technology. And on the other hand, it is crucial that we meet the challenges of the digital transformation. But the two can go very well together. Despite the digital transformation, we must preserve the characteristics, the key factors of land registry, and we need to ensure that the special features and legal traditions of all of our land registries are respected if and when possible. And on the other hand, we should not try to prevent automizing elements and procedures when computers can do the job better than humans. So there's a serious tension. We need to strive for a cheap, yet secure, trustworthy, and flawless land registration process as society is counting on us. The quality and completeness of land registries is one of the most valuable assets and the reason why we are held in high esteem. The quality of our work is a cornerstone of modern society and the rule of law. We must uphold this quality and ensure that the land registry really deserves its great value by its contents and by the way it has been established. A third element in present society partly derives from the need to urge to digitalize. This element concerns the gap between people who understand modern technology and people that cannot keep up with the computerization of processes, including land registry processes. And for this reason, we need to protect the vulnerable, the weak in society. This may sometimes be realized on a rather easy way by creating the possibility or maintaining the possibility to offer services on paper or in person. And the fourth topic in this present time is that we have to deal with, or we have to support, is that, if I would say almost, of course, the topic of circularity and sustainability. It will concern the activities and the methods and procedures of our land registry organizations, but it does also, and perhaps even more, concern the possibility to, for instance, service the registration and publication of additional information with regard to the constituent materials of buildings and complexes. And then I move to the final part of my speech, the future. One of the elements I picked for this talk, and these are not the only topics that I could have picked, is about international migration. An ever-growing number of people around the world are trying their luck in other countries. But there are also other less fortunate reasons to leave your country and to find an accommodation abroad. And this can be war or other crimes against humanity, but it can also be the consequence of climate change. In various countries, we have seen enormous changes. Talking about the Netherlands, my home country, we have seen rivers flooding, the settling of the peat soil, and even earthquakes. But we are not alone. If I recall the eruptions of volcanoes, for instance, La Palma in Spain, where the registrars came to the help of the owners of pieces of land and dwellings that were destroyed, and forest fires, hurricanes, and landslides on all kinds of places in the world. Living in countries with high temperatures may become impossible. Countries below sea level have to raise their dikes. People living in areas famous for ski holidays have to find other ways to gain income, and so on and so on. But it also raises questions concerning expropriation. Should it be possible for governments to demand from their citizens to leave their properties, to make adjustments to their properties in order to protect their dwellings from flooding and other forces of nature? Or should it even be possible for national governments to demand the reception in one's house of asylum seekers from, for instance, countries in war? With regard to the activities and the methods and procedures of our land registry organizations, one could raise the question whether we should surface the registration and publication of additional information with regard to the constituent materials of buildings and complexes. Should we or should we not register, for instance, the energy performance certificates? And should we or should we not register the status of quality of the foundation of a building? Perhaps we need to introduce and register the climate impact label on every dwelling. It's just an idea. Combining land registry data with all kinds of data generated by sensors or domotica could also be or become of interest. And finally, to know what materials have been used while building the dwelling or the complex, a register of materials may be created, helping the mortgage banks to comply to legal demands with regard to their mortgage loan portfolio. And then there is also the question, to whom do these data belong? Is it the owner of the property, the contractor, or the architect who designed the building, or perhaps the house itself? And the answer to such questions even become more difficult when talking about code-generated data. Perhaps we could create a method where all of these data are combined and stored in a three-dimensional model where it will be possible to show the objects and its rights, limitations, obligations, and materials. And that way, registering all of these data may become more easy, of course, depending on a technological solution that has been created. One could think of the use of so-called e-wallets, where a person can store data and documents, and where the issuer of the data or the document can approve the data or make attestations. For instance, a land registrar who puts a title into this e-wallet. But what does it tell you when this title or this dwelling has been issued yesterday and today the house has been sold? So actuality, correct data, are even more of the greatest importance. And could the object itself have a wallet? That's also an interesting question. And in that perspective, it's also worth mentioning the movement in many countries to give certain rights to nature. Depending on the solution or the legal format that has or will be designed or used, this might result in a true paradigm shift. Because, as we all know, a well-functioning land registry system consists of a triangle consisting of an object, a subject, and a right in rem. And deciding to make the object also a subject does change the triangle, which may lead to a registry that does not function as it should be. And this subjectification of objects is already examined or even in place in many countries. Many countries have made huge efforts to change perspectives between nature and humans. Nature has been granted rights and legal protections in, for instance, the constitutions of Ecuador, Bolivia, New Zealand and Colombia. In Ecuador, the constitution gives Mother Earth legal standing, if I understood correctly. And in New Zealand, the Wanganui River and other areas gained legal personhood. In Colombia, the Supreme Court recognized the rights of the Amazon River. And finally, in Curridabat, Costa Rica, citizenship to pollinators, including bees, hummingbirds, bats, butterflies, but also trees were granted. And trees can be seen as immovables, can also be seen as part of the registration process, possibly even in a local or territorial land registry system. So for my final point, I would like to address that it is of the utmost importance to cooperate and interconnect. Interconnection to other systems, for instance, the interconnection between land registries and cadastres, and cooperation between registrars using the expertise within IPRA-CINDER, and on a European level, IPRA, but also cooperation with land surveyors, notaries, and licensed conveyancers, judges, IT specialists, and academia. So we have a lot to work together, I think. And whatever we will decide concerning modern technology, for instance, blockchain and artificial intelligence, in close cooperation with our stakeholders and by ourselves, we need to prevent that people rely on IT systems without the acknowledgement of the experts. We need legal certainty because it's essential in order to keep and let the rule of law prevail. And for that reason, we have to embrace modern technology without the technology being truly disruptive. A technical system can never give this legal certainty without the approval concerning its functioning by the land registrar. The key elements for this will be about reality, reliability, and responsibility, and therefore about attestations by trusted third parties such as the land registrar, as people have to rely on land registries, especially when it comes to, for instance, blockchain-based land registry systems or the application of artificial intelligence. And finally, I promised you to get back to the slide stating the importance of land registries. This slide, with this text, it wasn't me writing this text. It also wasn't one of you or anyone else, any other colleague, any registrar, or any person in the world, because this text was written by a piece of artificial intelligence. It was written by ChatGPT, created by OpenAI. And the same goes for the pictures I used in this presentation. They were created by Wall-E. I asked the software to draw pictures on the basis of my texts. So that's the state of play at this current moment. ChatGPT is a prototype of a chatbot with artificial intelligence, specialized in conducting a dialogue with its users. The problem is, it looks great, it feels great, it gives the idea, also because of the user interface, that the computer does understand you and knows what you want to know. And by the continuous typing the answer to your question, it looks like it is really thinking over what it should answer. But in fact, it isn't. It's just a replication of data that it has learned, that it has been fed with. And then the most important part is, what kind of data did feed that system? Was that information that has been attested by professionals, by experts, or not? Its successor will be ChatGPT 4 next year. It will be published later on, and it will do exactly the same, but with a much higher volume and better power and more knowledge, because it's more actual. But is it knowledge? That's the question. So it has a lack of understanding. It cannot understand intentions. It hardly ever asks for clarifications, and it delivers only one response, unless you ask for alternatives or regeneration of the answers. GPT stands for generative, pre-trained transformer, and that's just what it is. And exactly this is the reason why human interference is of the utmost importance when it comes to the true understanding of intentions, thoughts, and problems. Despite this, according to the New York Times, Google has called the help from the founders who left 3 years ago and sees ChatGPT as a threat for its own existence. Google. While Microsoft is planning to use AI of ChatGPT in its own search engine called Bing. Ladies and gentlemen, I've come to an end. I want to congratulate once more IPRA-CINDER, and in particular our Secretary General, Alfonso Candau, and the founding members with this wonderful commemorative event and the incredible history that has been created by the members of IPRA-CINDER throughout 50 years of hard work in preparation of and during these 22 congresses. I'm looking forward to meeting you all again next time, people attending this event online, but also here in Brussels, in Costa Rica at the 23rd IPRA-CINDER conference. But first, let us continue our celebration with the next topic of the agenda. So thank you very much.
Thank you, Mr. Bosch. We continue with the roundtable, moderated by Luisa Clode, President of IPRA, with the topic, the evolution of land registries over the last 50 years. Please.
Well, good afternoon, and I want to start this roundtable. I will just move to the roundtable in a few minutes, and by congratulating IPRA-CINDER in the person of Alfonso Candau. I want to congratulate also the representatives of the founding members, and I will ask the panelists then to join me at the roundtable. Well, I want to welcome you to the roundtable, and I just wanted to share with you some words, because I just had the honor of listening to all the previous speakers. And I want to thank you so much for the participation, and thanks especially now to Jacques Vauche for the excellent lecture you brought to us. Although I was somehow afraid about artificial intelligence, but that's what we have to adapt to. Well, as you have just referred, the changes and the challenges that the world is facing demand, I would say, in addition to solidarity, but these changes demand cohesion. They demand strong institutions built on the work of expert professionals that provide and enhance trust, bridging diversity and bringing added value to the economy, and thus contributing to social justice and peace. So, because you spoke about changes, now boosted by, of course, the unavoidable technological revolution, and I would say that it requires also adaptation. And so allow me to recall what Charles Darwin once said: "It is not the strongest of the species that survives, nor the most intelligent. It's the one that is the most adaptable to change." So that's what we need to have in mind. Well, the digital transformation we're going through, well, I must say, always bounded by the respect of human fundamental rights, and the futures of the registries involve precisely this adaptation, always guided by and respecting its principles of legality and independence, ensuring accuracy in the information we registrars provide. Well, but registries and IPRA-CINDER, and I will not take long, have also the virtue of bringing us professionals together, interconnecting not only information, but mainly knowledge, which is somehow different, and people, fostering friendship. And friendship is also one of the best outcomes of IPRA-CINDER, allow me to say. And as regards the Congress I had the honor to organize with my friends in Porto, I must say that it was one of the most relevant achievements of my professional life as a registrar. So I want to seize this opportunity to thank IPRA-CINDER for always pooling efforts on registrar studies, and for the opportunity offered to the Portuguese registries and registrars last year. We're going through some difficult times, but we keep steady. So I want to say that together, like the Portuguese Nobel Prize once wrote, well, together we are not simply more, we are certainly better. So, my apologies for taking these minutes of your time. I know we are running out of time. So now I have the honor to introduce the participants. I would call José Antonio Saavedra Calderón to come to sit with us. Welcome, José Antonio. So Ricardo Noboa Ganan. And Mr. Tunas, Sadetin Tunas, I know he went outside, but we will just wait for him for 1 minute. Are you joining us? Okay. I'm sorry, you just arrived today. Uslam Ajono. So you're okay, from Turkey. So Turkey is the newest IPRA-CINDER member. So I'm very pleased to have you with us. Thank you. So I will just, okay. So just a few words about José Antonio Saavedra. I will continue speaking in English. So José Antonio is a lawyer and professor at the Sant Ignacio of Loyola University. He is associated member of several international organizations, such as the International Academy of Comparative Law and the Society of Comparative Legislation, both with headquarters in Paris. Mr. Calderón graduated at the University Inca Garcilaso de la Vega and has has master in civil law at the Pontificia Universidad Católica from Peru. He also studied comparative law in the University of Paris and doctorate from the University Nacional Mayor de San Marcos in Peru. Mr. Calderón has taught on public international law, private international law, mediation, conciliation, and arbitration, and was Dean of the Faculty of Law, Political Science, and International Relations of Technology University in Peru. He has been Assistant for Legal and Jurisdictional Affairs of the Ministry of Foreign Affairs of Peru in Switzerland and in the Netherlands, if I'm not wrong. And Mr. Calderón has actively participated in most IPRA-CINDER congresses, namely in Oporto last year, and the Peruvian Institute of Registry Law, which he represents, was co-organizing of the 17th IPRA-CINDER Congress in Lima, where among others, themes was discussed the adverse possession against the registered owner. So, please, Professor, the floor is yours.
Thank you very much.
Thank you.
Gracias. Permiso. Muy buenas tardes a todos.
Good afternoon, ladies and gentlemen, Mr. Alfonso Candao, General Secretary of IPRA-CINDER, Madam Luisa Claude, President of ELRA, ladies and gentlemen, registrars, authorities. I have been invited to this roundtable on the topic of the 50th anniversary of IPRA-CINDER, and I would like to thank you for that. It's an honor to be here. If I keep talking about what you asked me, I'm going to be brief and explain what you have asked us to explain. In the 60s, there were profound changes in the world. You might remember that in South America, we were living the impact of the Cuban Revolution in 1959. It was extended in South America with a huge impact. In North America, we could see Martin Luther King. He was the pastor who was vindicating the citizens' rights. There was a decolonization process in the world at the time. New concepts were appearing, for instance, environment. And in Europe, there were also some effects of the May Revolt in 1968. At that time, there was a Cold War, and there was a struggle between both hegemonic powers. In South America, many of the countries lived under military regimes. There was a caudillo framework. We had this idea in South America that there was just one person who was going to solve all the problems of the country. And there were also other doctrines such as liberation and theology. This was the church of the poor ones. It was focused in the poverty, in concentration of land. And we could already feel at that time something linked to ownership, land ownership. There was something which was not formal, which was not organized. It was insufficient. In 1968, in Peru, there was a military coup d'etat. It came from a revolution. And they talked about the agrarian reform. And in 1968, in that context, we can see the Peruvian Public Registry, which had its headquarters in the basement of the Judiciary Ministry. At that time, we had these huge books full of written notes, and different acts and contracts were included in handwriting. There was such a transition. There were some board cards, some red, some yellow, some blue, and we were typewriting things at the time. But it was also a very concerning moment for registrars, because somehow they have to show that they were worried At that time, the chief of the register was the military. It was a colonel. And the colonels, they were the ones who ordered what had to be included in the registry. Please register, just write that down. And there were just two possibilities here. Yes, of course I'll do it, or no, I don't want to do it. So if you said, yes, of course I'm going to do it, there was no warranty for the registrar. The person would be able to be there, but whenever they refused to include something in the registry because they didn't agree to do that, then they wouldn't be able to work in this land registry, but they would be just moved to the commercial registry, as if it was something worse. And then there they would find another colonel, another chief, and then they had to either accept or not accept. And whenever they rejected, then they were moved to another post. So this is the context. This is the history we had at the time. So registrars were worried because they wanted to understand what was going on in the world. And at that time, we held the Congress in Argentina in 1972. I wasn't 10 years old, as our colleague Ismael Molina said before. I was 2.5 years old. But I have heard many things about the Congress. My mother, she was a registrar at the time. And I asked where she was, and I was told she went to Argentina to go to a Congress. And she was there, and she participated in these first debates about registry law. So people were curious. They were eager to know how other things worked in the world, other legal systems. So thanks to that, a Peruvian delegation went to that Congress. And thanks to that, in Peru, the first non-lucrative organization was created, the Institute of Registry Law. At the beginning, it was like a guild. It gathered different registrars who wanted to work together, who wanted to follow this reality and to learn more. The Institute was also worried about how to specialize, how to train their members, and they were following the Charter of 1972. This charter recognized the importance of developing registry law. This is the basis of universal principles for registry law. And sometimes there are legal constraints, but anyway, they can be developed and they can be included in the doctrine. And for me, this Congress, 1972, was one that recognized the importance of property and registry law as a main branch of law, as something which is important in law, and it is going to take into account key principles. For instance, the presumption of accuracy, because this is important. Whenever we do not have a ruling coming from the court, we can assume something is certain because it's in the register. And we have seen that later on there have been different modifications and amendments of the civil code and different laws and acts, and some have not taken into account things which already appeared in this charter in 1972. For instance, the bona fide, this principle, or the buyer who has also a good faith, these kind of things. In Madrid, we had a Congress which helped members from South America to explain their different systems. They were able to present their systems and even get further. For instance, in Peru, we were able to talk about the torrents system, and also France and Germany were able to present their systems, and we were able to reflect all together and to learn, and this had an impact in different laws which appeared afterwards. In 1977, we had our Congress in Puerto Rico. And I could see the transcriptions of the debates. And for instance, I read a very interesting sentence which recognized in their memories Miss Maria Luisa Fuster. In the conclusion, she was considered like the soul of the Congress. It was thanks to her that the Congress took place. The Congress in 1974, I'm going backwards now, mentions José María Chico y Ortiz. If you are registrars and you have been studying, I'm sure you know what he wrote. They have a very important piece of work. And also García Coni, Scotti, Alterini, Antonio Leiva, Andía, Eugenio Fernández Caballero. All those appeared here. And I remember this person, he had an important character and everyone knows him because of this. He was a Secretary General afterwards. And we could gather 33 countries at that time, and 13 were coming from South America. So you can see the importance of this event. For us, it was something really important. In 1977, there was tenacity, a dedication of María Luisa Fuster, as it appears in the conclusions. 1980, the Congress was held in Mexico. And for me, it was very important because topics such as property and its social role were tackled. In Mexico, as you know, they can propose a topic whenever they are hosting, and then the other topic is proposed by the Secretariat and CINDER, and there was a mixture of both. So there are two topics, one depending on the reality of the country which is hosting the Congress, and the other one which is a general topic which concerns all the members. And in Mexico, different tensions were recognized because there were issues with the land property, for instance, the human settlements, demographic pressure, the presence of the state in the land domain, the lack of an efficient policy, different topics which are very common for us. For instance, the dead letter, the blank law, the one which is written but nobody uses it, no one complies with that, or the virtual rights. And we were already anticipating the huge revolutions to come. At that time, the virtual rights were the ones which were there, but no one knew what happened to that because they were not something material. Human settlements, demographic pressure, as I said, and also the precarious titles and deeds. Those which were recognized, there was a title, there was an instrument, but they were not efficient, they had no value because reality just appeared. So there are some countries in Latin America, as you might know, that they still live like that today. And these are continuous, ongoing threats for those countries.
Estamos en épocas ya de don Rafael Arnaiz.
Then we can mention Rafael Arnaiz. I would like to greet him here today. I'm talking of Fernández Caballero, Scotti, Emily Calderón, López Medel. And I also found something else which was interesting. Mr. De Grolier. He was a Belgian official who talked about the responsibility of curators of mortgages as warrants of publicity. So we can also see Belgium here. We also saw Manuel Moroz, Franco Cattaneo in Switzerland. I don't know if you remember him. He was an Italian, Swiss-Italian who spoke Spanish very good, and we really liked him. I don't want to talk about all the history and all the background here, but I would like to mention and highlight the importance of all those topics that have been tackled throughout the Congresses, because all those have evolved. From the 19th onward, something very interesting appeared. I'm talking about the inclusion in this registry law of the economic analysis. All these concepts, which already appeared in the Charter of Buenos Aires, the social function, the social role of ownership already appeared that. We see it afterwards, the law and the economy. For instance, fight against fraud. That was something which was happening in several countries, at least in South America. Or the reinforcement of private property. We talked about that in Russia. You might remember that when you were there. There was an incident a few days after the launching of the Congress. There was a mysterious death. Someone who was going to talk about private property died. And Russia was getting into a transition towards registry. And this was going to have an economic impact for the country. The prescription of acquisition, this is a topic which is still a problem for Peru. We saw that in 2010. Fernando Mendez was there. There was some interesting debate. I remember I was the moderator, and it was a very complicated roundtable to moderate. And I had to leave Fernando more time so that he could keep talking, and we have talked about that several years ago. Enrique Rajoy, Nicolás Noguerol. I can't remember all the difficulties we had at the time, because it's always hard to start. And I remember we asked for a date at the Embassy of Spain, and they never answered us, and we didn't know what to do. We don't know exactly what happened. I'm talking about the time of Enrique Rajoy, and they called us and they told us, we want to talk to you, or we would like to invite you to dinner, we want to have a discussion, and they were supporting us. And this was just a moral support, but it was enough to show us that this Congress had to be celebrated. These Congresses have always been very close to reality. We tackled the agenda of the hosting country and the agenda of CINDER at that time. But now, the agenda is the same one, because we're all facing the same issues, the same problems, the same threats. At the end, the problems become threats, and somehow they have already been tackled or developed in one or another Congress. We have different challenges nowadays. For instance, environmental protection, implementation of sustainable development goals, which have been developed in the last years. We have the Agenda 2030, and nearly all countries have committed to complying with this agenda. And these challenges, as I see it, are going to allow us to reinforce common values for community. This is going to help us to cooperate even more. Whenever we have to face things such as money laundering, organized crime, the only way to do that is communicating amongst ourselves, to cooperate. We have been talking about technology here. This is a threat. And we have also talked about artificial intelligence, databases, 5G, robotics. And as I see it, this is an opportunity for integration and for cooperating at international level. In Peru, we have a program which is called País, Country. And sometimes we share objectives, but we have different speed. We are doing things at a different pace. So what we intend to do in Peru is to join the OECD. In order to do that, we have to implement different topics, and some are linked to digital transition. And this is what we are trying to do right now in our registries. This is our goal. We're facing some issues with the databases, because data are too fast, and whenever there is an issue with security, data are spread very quickly, and this is dangerous, and some information can be exposed, and we have an issue with privacy here. I would like to conclude my explanation here just thanking everyone for the solidarity I have received in Peru these last weeks. some things which are hard to understand do happen. And even the registries and the registrars have suffered an impact due to what has happened, because we have had an issue with our documents and our equipment and so on, and we have to recover ourselves, and we have received so much solidarity from all of you. So thank you so much for that.
Muchas gracias, José Antonio.
Thank you very much, José Antonio. It was very interesting. I'm going to switch into English.
Strengthening the fundamental views of humankind, which is really important, and the registries have also a role to play in this topic. So I will just inform the audience that we will have time at the end, which I'm not sure, we'll do some questions and answers, but let's move on to Ricardo Noboa. So Mr. Noboa is from Dominican Republic. He's graduated at the Pontificia University Católica Madre Maestra, where he did his master's degree. Ricardo later attended the Autonomous University in Madrid, the specialization on registry law. Ricardo is nowadays the Secretary General of the Ibero-American Registry Network, the IBEROREG, an organization that aims to promote the understanding between registry organizations and between these and the public administrations of the Ibero-American community of nations. And likewise, we do in ELRA, wishes to promote the registry interconnection for both private and public purposes. He is also the National Director of Judicial Branch of the National Directorate for the Registration of Titles. Mr. Noboa teaches registry law at the Ibero-American University in Santo Domingo and at the Pontificia University Católica Madre Maestra, where he also teaches property law. Well, you have been participating in several international conferences, of course, like some of the IPRA-CINDER, but I will move on just because we're running out of time, and the floor is yours, Ricardo. Thank you so much.
Muy buenas tardes a todas y todos.
Good afternoon. Firstly, I would like to thank Alfonso Candao, the Secretary General of IPRA-CINDER. And I'd like to address my words to Maria Luisa as well, the President of ELRA and a friend of mine, as well as to Maria Emilia Aran, the Chair of the Spanish Association, and I want to thank everyone in the room. Good afternoon, everyone. In our case, we're going to see the evolution of property registries in my country, in the Dominican Republic, and how the Dominican Republic has used IPRA-CINDER in order to learn, to apply good practices, and to streamline our registry systems and to understand where we want to be in the future. In that, I'm going to try and keep my words to the time that have been allocated. And this is just a brief history of the past, the present, and the future, so that we remember where we come from, what our evolution has been, and then we'll understand how to apply current strategies and we'll decide on our future projects. I'm going to be very brief, but at the same time, there are a few important background elements that I would like you to be familiar with. As you know, in 1844, we became independent, and immediately we had a new informal system as to ownership and buying and selling property. 1 year later, our country adopted the Napoleonic Code, the French Code, and that topic was regulated in that legislation, but it wasn't until 1890 where the Law 2914 on registration and preservation of mortgages was approved. That was after the Napoleonic Codes again, and that was when the French ministerial system applied in our country, but it was already included in our legislation. That French ministerial system wasn't well managed. It wasn't operational, and it couldn't be applied to buying and selling property. So in 1916, the intervention by the United States of America happened due to some political aspects and due to interests of the US in the Dominican Republic, specifically sugarcane exploitation. And the use of sugarcane obviously had to go via property, and the French ministerial system in the Dominican Republic wasn't adapted, and it didn't really work with buying and selling property. That intervention government by the US started looking for a good registry system that could be used in the Dominican Republic to defend their own interests. The US was applying the Torres system in many countries, and the Torrens system was their source of inspiration, so that in 1920, that Torrens system was officially approved via the 511 administrative decree. That system is not exactly the Australian Torrens system. It has slight modifications. You need to understand that different countries have different needs and different realities. And the Dominican Republic at the time had specific needs. There was a lot of fraud in property law, forged property documents, and there was a very high demand, and the system at the time couldn't cope. So the Torrens system, or our variation of the Torrens system, included a specific court, the High Court of Lands, and that was a second degree court that basically was the center of the system. The system was then managed by a court. That could be surprising nowadays, because courts cannot manage registries, because registries try to avoid conflicts. But remember that at the time there were many forged documents, all sorts of manipulation in property law, and that's the reason why the Dominican Republic adapted the Torrens system, including a specialized court. And then a deeds registry office was founded, charged of managing the publicity and the rights of those documents, and it also included a General Directorate of Cadastral Measurements. That's a technical body. So from the moment of registering a property, you need to measure, you need to carry out technical measurements of the plot. And that's the reason that this General Directorate was established. And this new system in the Dominican Republic added one more modification to the Australian system, which is to allow portions of land, so portions of property could be transferred without measuring first. So obviously this generated chaos in buying and selling property. There was a specialized court, as I said. So each transaction had to go through a court that made transactions very long and very costly. There was a first reform in 1947 to that system. It basically keeps the same idea of having a centralized registry, but it implements new processes, new legal processes, new judicial processes, and it maintains the possibility to buy or sell portions of land without measuring first. This of course goes against the original Torrens system. I'm going to show you some photographs, some pictures, so that you understand the management of the registry at the time. We're going to see pictures from the end of the 90s and the beginning of the noughties. You can see them on the screen. These are registration documents, deeds, obviously handwritten at the time. In some aspects, we could say that the staff and the registrars had good handwriting, but some other people didn't write that well, and it wasn't very understandable. And of course, that made it much more difficult. It was difficult to assess or to qualify or requalify or to answer to a query. As you can see, the experts had to measure and then draw the map manually. And of course, it included mistakes as to where a section was included in a plot of land. Here you can see some pictures of the management. Unfortunately, the registry was managed, as you can see at the screen, not very tidy. Then you can see that checking something in a book was something that was done manually, completely manually. So obviously that means the deterioration of the books little by little. Some people were more careful, some people were less careful, and many situations happened, many unfortunate situations. So everything you've seen on the screen led to a second reform. And some of the causes were, for example, the substantial increase in real estate development in the country. And then the Torrens system had to be adapted to modern times. And that needed a solid and modern legal framework. There was a complete absence of rules on the organization, the operation, and the management of the bodies of the registry system, as you saw on the photographs. And it was necessary to have a new management model that was dejudicialized, with no presence of courts. And new technologies had to be taken into account, because measuring was possible at the time and manual work was not necessary anymore. Like I said at the beginning, portions of land could be bought and sold. That grew in a disproportionate manner, and it affected this legal certainty, and therefore those transactions had to be banned in the new Torrens system in our country. So firstly, all information had to be recovered. You can see in the photographs, some of the documents were completely destroyed or partly destroyed, and it was very difficult to check any registration, any annotation. So all archives around the country had to be restored and then digitalized, so that the content could be extracted and integrated in databases, so that data could be checked not just by registrars, but by anyone in society and by any citizen that had to have access to the registry. You can see current photographs where archives are properly organized and documentation is properly maintained. And then users can access themselves. As you can see on a computer, they do not have to access a book, a hard copy. So that's the second reform, and the current law is Law 108/05. That's been operational since 2005. The court is not the manager of the system anymore. There's still a court in case there is a dispute. The specialist court can act, and that means that we have an advantage compared to other systems, because courts have already become specialized in property law. So we can keep the essence of the system. In some other countries, we can see that courts and registries do not understand each other, and they have very different principles. Well, obviously, the dejudicialization affected many processes, and the new reform strengthened the registration principles, and it allows for the appearance of new technologies in all processes. So let's speak about the present time and what we have been doing recently. I have to mention that something that impacted everyone was the pandemic. The COVID pandemic was a catalyst, and it accelerated many processes. in all fields and also in the registries. So in 2020, our country digitalized 100% of transactions at our registry office. So that means that during lockdown, we could still apply the publicity principle via virtual offices. So users could have access from their own homes because we had the obvious limitations due to the pandemic. And then we started a process of consultation of public documents and virtual appearance of users. So anyone can apply for an appointment online with no intermediaries. Citizens do not need to go physically to the office. They can have a virtual appointment with the staff from any country, any city in the country. So the advice of registrars to citizens can be done immediately online, and that avoids hours and hours of traveling to the offices. At the same time, consultations of the cadastre are possible as well. I told you that all plots of land, all parcels have been digitalized, so anyone can access the cadastre online. And then there is an unmanned warehouse. We have offices across the country. We have 24 regional offices. So users do not need to go to the office that is closest to their city. They can go to any office, but we also have an unmanned warehouse with different mailboxes. Public documents can be checked online. And then we also have what we call appearance kiosks, or single windows. If you do not have access to technology, you can still go to a physical office and you can still have access to the information. And as to the future and our future projects, I would like to mention the digital signature. That's the registry and cadastral qualification. We intend to use digital signature and dematerialize real estate collaterals in the Dominican Republic, because still controls have to be made on paper. We are working on the transition to digital. We want to strengthen interoperability with the public and the private sector, between both sectors. And as to the use of artificial intelligence, I want to make it clear, we do not want to replace registrars. We just want to help registrars with artificial intelligence so that all the preparation can be done by the machine. So the machine can submit a proposal and then the product is almost finished and the registrar can finish that product. And by the end of this year, we will implement the registry alert. Many countries have that system. In our country, we have just started working on the project. We'll finish it by the end of the year. And I'd also like to mention the certification of the quality management system under the ISO, the ISO standard, the 9001-2015. So those are the projects. We will keep adding projects depending on the work of our registry. This is the end of my presentation, and I hope that if you have any questions, I will be able to address them at the end of the debate.
Thank you, Mr. Noboa. It was very interesting going through these years at the Republic Dominican. And, well, there is some references to your work. We have all been speaking about technology and modernization. Maybe we should also think of the need of permanent updating of the digital tools we are using, but maybe that would give another seminar or another celebration. Okay, so now we move on to Turkey. So we had the pleasure to listen to the founding members. Now we have the newest member of IPRA-CINDER, here represented by Mr. Saadettin Tunis. Mr. Tunis received his undergraduate education at the Faculty of Economics and his master's degree in real estate development and management. You have started to work as a cadastral technician, land registry officer, assist land registry director, and land registry and cadastral expert. and you continue your duty being now the head of the Foreign Relations Department in the General Directorate of Land Registry and Cadastre in Turkey. Mr. Tuner has experience and knowledge in land registry applications, land administration, real estate valuation, and real estate acquisition by foreigners. You have been given many trainings and seminars in these fields. Well, I was looking for some information about you, and I found that your organization website, the following: guarantee of ownership from the past to the future. That's what we are dealing with. So, Mr. Tunis, the floor is yours.
Thank you. On behalf of the General Directorate of Land Registry and Cadastre, I, Saadettin Tunas, the head of Foreign Affairs Department, I would like to start my speech by greeting IPRA-CINDER, also ELRA, two important organizations for land registry structure. Dear participants, would like to greet you all and congratulate the 50th anniversary of IPRA-CINDER, of which we are honored to be a member since last year. And I wish you many more prosperous 50 years to come. Due to the honors of my voice, my colleague Özlem Hacıoğlu will continue the presentation that I planned to make. Thank you for your understanding. Please, Özlem.
Hello, dear participants. Due to a change on a short notice, I'll be presenting today because of the harnesses of Mr. Tunas. So I apologize in advance for any mistake, and I am sorry that you have to listen to me today.
No.
First of all, I want to give a small information about me. I am Özlem Hacıoğlu. I graduated in law school in Turkey, and I used to work as a lawyer, and then I decided to change my career and started to work as a specialist of land registry and cadastre in Turkey in our General Directorate. Excuse me. I want to give you a brief information about the presentation. Our presentation will be briefly cover the following topics: an overview of the General Directorate of Land Registry and Cadastre, the competent institution responsible for keeping the land registry in Turkey, the legal basis of land registry, evolution of land registry from traditional method to electronic registry and title deed transactions in general, functions of the electronic registry, applications integrated to electronic registry, and finally, the future of the land registry. The land registry is kept by the General Directorate, which I am working for, in Turkey. General Directorate of Land Registry and Cadastre provides services throughout the country through a total of 18,000 personnel working at 24 regional directorates, 973 land registry directorates, 81 cadastre directorates, and one overseas branch which performs a service in Berlin, in Germany. The main regulation regarding to land registry and immovable property are regulated by our Turkish Civil Code. While originally only land and independent and permanent rights were recorded in the land registry, in 1965 the condominium, and in 1997 the floor easement, in other words, incomplete independent sections, began to be recorded in the land registry as immovables. Over time, land registry started to gain importance as it has the data needed by many public services. The Turkish land registry was initially created using traditional methods. In addition to the traditional land registry method, which is still being used, an electronic registry has been created in order to benefit from the developments of information technologies and to meet the increasing transaction demands quickly and safely. The cadastral works that started in 1925 in Turkey was completed 100% as of 2010. The land registry was established between these dates based on these completed works, and as of this date, there is no immovable property that has not been recorded in the register. As it can be seen, it took almost a century to have a full coverage cadastre in Turkey, since the country has a large surface area with various topographic structures. There is an example of title deed page. Traditionally, the basis of land registry is title deed in Turkey. A title deed page consists of 4 main columns. From left to right, you can see, there are the columns of initiations, property easements, rights and immovable obligations, and immovable mortgage rights. The electronic register, which was completed between 2002 and 2012, is being kept throughout the country simultaneously with the traditional register. The electronic register is kept by a system called the Land Registry and Cadastral Information System, which we call it briefly TACBIS. In TACBIS, there are approximately 57 million plots, 20 million independent sections, and 190 million owners. Land Registry and Cadastral Information System, I said it TACBIS briefly, which can be called an electronic land registry, protects the property data as well as allow users to carry out title deed transactions. In this way, it's ensured that the title deed transactions are carried out more quickly and safely. In recent years, with the increasing population and the introduction of immovable property as a financial investment tool into the developing business world, the acquisition of immovable property is now seen as a profitable investment tool. In this context, immovable property transactions have become more important more than ever. In Turkey, approximately 3.5 million land registry transactions are carried out annually, including 2.5 million sales, and an average of 30 million people are served annually. Functions of electronic land registry. Transition to electronic registration has been most effective and useful in the field of data sharing. Electronic land registry system allow institutions to share data, access to electronic registry, and even perform registration transactions such as liens, mortgage, etc. Electronic data sharing with the stakeholder institutions allow us to save time, labor, and transaction costs. Thanks to the electronic registry, registered transactions such as mortgage release, lien, and collection carried out in cooperation with our stakeholder institutions can now be carried out electronically by relevant institutions. Now I want to mention about the applications which are integrated to electronic land registry system. The General Directorate of Land Registry and Cadastre, which is the institution responsible for keeping the land registry, has developed many projects integrated to TACBIS electronic land registry system, keeping up with the current conditions and technological advances. The main ones are follows: Web Land Registry, we call it as Web Tapu, Maxis, e-Archive, and 3D Cadastre. One of the applications designed as an integrated part of TACBIS is Web Tapu, or in other words, Web Land Registry application. Using this application, users can initiate registry procedures online and obtain a sample of title deed registration. In addition, by using web tapu owners, the property can grant the owner of the property can grant other people authorization to view the title deed information and make applications or revoke their authorization in a secure way. Another application designed as integrated part of TACBIS is MEXIS, Spatial Real Estate System. We call it briefly MEXIS. MEXIS is one open source application prepared by collecting data from the local computers of the cadastral directorates on a central system and matching them with the land registrars. Besides, parcel search application developed by using the MEXIS data model allows users to access the location area, characteristics, and section information of immovables. All users can access the parcel search application online. It's currently 3 million users daily. Another project facilitated by the transition of the electronic land registry is the 3D cadastral model design project. With this project that is designed to promote the effective land administration approach in practice, 3D cadastral data model designed, sorry. 3D cadastral data model designed real estate valuation, integration, and parts and application were carried out in a pilot city. These applications aim to generate the 3D cadastral data set and design the working models. You cannot manage what you cannot measure. Business intelligence, which is based on the collection and analysis of the necessary data for faster implementation, is designed to support the electronic registry. The main purpose of business intelligence is to reach a logical solution. It consists of the following components: reporting, multidimensional analysis processes, and data and process mining, complex incident analysis. Now I want to talk about future of land registry and cadastre in Turkey. In today's world, where digital government services are becoming more widespread, the importance of the e-registry services is increasing as well. In this context, the aim is to offer the land registry services more effectively and efficiently by using e-registry more actively. As a part of digital government services, it's planned that the traditional land registry records will no longer updated, and the entire land registry records will be kept by electronically fully. The aim is, The aim is to ensure the sustainability of the electronic land registry by updating and improving it as a technological advances. This presentation has been prepared as an outline to save time. The detailed version of our study submitted to IPRA-CINDER. Thank you very much.
Well, thank you so much. It is very interesting for us to get to know something about what's going on in Turkey. So thank you once again, and congratulations for the evolution that your system has been going through. Well, I wonder if we still have time for some questions. We are running out of time. But I will, Carmen, I will allow myself just one question to all of you at the same time, if you agree. We spoke about the use of technologies quite a lot, and I mentioned previously the question of updating these technologies and the way we use the data there. There is another issue that we are dealing with in Europe, which is related to an act that's been approved by the European Union, web services, about the web services providers. There is a general concern that this set of data must be kept within the borders of the European Union, not only for security reasons, but also for data protection. So when we are speaking about the present and about the future, my question to which of you is whether you also have these concerns in your country. Where do you install the data that we gather in the registries, and what are you doing for the protection of those data? So I wonder which of you would like to start.
Okay. Şimdi yani veriyi nasıl saklayıp koruduğumuzu soruyor.
Teşekkür ediyorum. Takvis veri tabanı merkezi sicilde tutulan bir kayıttan ibaret.
Thank you for your question. We are keeping the TACPIS in central database in our general directorate.
Sistemin içerisinde her türlü tapu ve kadastro bilgisi birlikte mevcut.
It contains all land registry and cadastral data.
Yapılan çalışmalarla birlikte takvis veri tabanını 3 ayrı sistem ile birlikte tutuyoruz.
All data is kept in a central database, and it is also aimed to ensure that the data kept securely with the centers established to recover data in case of disaster.
Birçok kamu kurumuyla tapu işlemlerinin ilgili kurumlarca yapılmasına ilişkin elektronik entegrasyonumuz mevcut.
We have electronic integration with other public institutions.
Bunların hepsini web servislerle sağlıyoruz.
We are ensuring the sharing data with web services.
Birlikte çalıştığımız kurumların hiçbirisinin merkezi veri tabanına erişim yetkisi yok.
And none of the institutions that we are working with our stakeholders, they have no limit to access. They have no allow to access information in our system.
Bütün güvenlik kurallarını kendimizin yazdığı web servisler ile diğer kamu kurumlarının tapu sicili üzerinden işlem yapmasını başarılı ile sağlıyoruz.
We give them information with our system, but they have no access.
E-ipotek işlemlerine örnek göstermek istiyorum.
I want to give an example with e-lien.
30'a yakın finans kurumu ile
e-mortgage.
30'a yakın finans kurumu ile yıllık 2 milyon adet ipotek işlemini sistem üzerinden ilgili finans kurumları üzerinden yapıyoruz.
We are working with about 30 financial institution and kaç tane yapıyorlar?
2 milyon.
They are doing 2 million transactions in our system. They are doing mortgage transactions in our system, using our system.
Daha büyük bir sistemi Adalet Bakanlığı ile geliştirdik.
We integrated, we make this system with Justice, Ministry of Justice.
Yıllık 10 milyona yakın haciz işlemini doğrudan ilgili kurum gerçekleştiriyor.
Approximately 10 million liens transactions is be done with Justice, Ministry of Justice persons.
Web servisleriyle tapu sicilin taraflarını, yapılacak işlemin esasını kontrol ederek başarılı ve güvenli bir şekilde diğer kamu kurumlarına tapu işlemlerini yaptırıyoruz.
We are controlling via web systems, so we ensure the other institutions to make transactions at our system.
Teşekkür ederim.
Thank you.
Okay, thank you. Any of you? No.
Solo pido que me traduzca al español la pregunta.
Perdón, Ricardo. Que estaba preguntando con esta preocupación de mantener los datos actualizados, que tiene que utilizar servicios online.
She's translating the question into English. She's repeating the question.
Las personas que providencian estos servicios. La pregunta es, ¿a dónde están los datos que vosotros almacenan? ¿Se quedan en la nube? ¿O cómo lo hacen la protección de datos de los propietarios? ¿Dónde están los datos? Es esto.
Bien, en República Dominicana.
In Dominican Republic, we protect data in local servers. We are also concerned about how to transfer all that to the cloud, and we need to see how to work in this protection with the providers. So right now, we have everything locally in the registry in our institution. Locally. And how does it work in Peru? In Peru, in order to protect data, we have the National Authority of Data Protection. It belongs to the Ministry of Justice, and there are 3 people who are in charge of making sure that all data are correctly protected. But I think there should be some harmonization with registries in order to know which data do not to appear publicly. For instance, when someone asks for information, we need to see what they can access. Imagine there is an accident and there is a car and the car crashes and then they flee. And if we have the plate number, we can directly introduce it in the system, and we can see everything about this person, and we can even see if this person is married or not. And I think that there is too much information publicly, because of course it's useful information, but I think this has to be controlled somehow, because in this case we are having this crash, but sometimes there are very bad practices, and someone has seen the car and they just want to check everything about this car, and maybe they want to steal the car. So transparency is fine, but sometimes it involves a risk. So we need to see how this is regulated in the registries. Regarding your question about web providers, we do not have that many citizens. We have an issue, but we do not have enough strength to go in front of Microsoft, Google, and to tell them, the four big four, to tell them that we want something in order to protect our data, because now everything is happening between China and the United States. And maybe you're in the middle in the European Union and you have your specific regulation and framework and you manage to work on that. But in the rest of the world, there is a gap here. And I think that we need to be careful with that, because there is some sensitive information and non-reserved information, and we have different habits, and we have to take care of this, because sometimes information is not updated, and sometimes this non-updated information will be useless. So maybe we can learn about the European rules, and we can see how to deal with this in the future. Because probably we like some system today, but tomorrow we will like another one. Yes, of course, as we were saying, it's just adapting ourselves again. Thank you very much, José Antonio. I think this is all for now, so I'm going to give the floor to Carmen. Thank you very much. Big applause to you all.
Well, time flows and we are coming to the end. I suppose many of you had the chance of watching the video, the commemorative video, and I think it's a must to view it now, right now. Thank you.
50 años para la vida de una organización no es mucho, pero en la vida de las personas, en la vida humana, es una cantidad de tiempo relevante. De hecho, del acto fundacional, que queden vivos, me parece que solamente queda una persona.
No sé si soy el único superviviente del primer Congreso de Derecho Registral. se celebró en Buenos Aires del 26 de noviembre al 2 de diciembre de 1972. Tuvo dos conclusiones importantes. Una fue la redacción de la Carta de Buenos Aires y fundamentalmente conectar una serie de delegaciones de distintos países.
Inicialmente en el acta fundacional sustancialmente era una reunión, unas conversaciones de registradores de ambos lados del Atlántico, fundamentalmente españoles, portugueses, con registradores centro y sudamericanos.
Se trataba de cambiar impresiones y de ver cómo eran las distintas instituciones registrales en todos estos países.
Una especie de asociación que enseguida cobró fuerza y que provocó cierto entusiasmo entre todos los asistentes al Congreso, y en el que se nombró secretario general del primer organismo a Scotti.
Até hoje vivemos sob a égide de uma lei que foi inspirada pelas conclusões do CINDER de 1972. Neste congresso do CINDER se estabeleceram as bases que serviriam para a remodelação do sistema registral brasileiro.
Entre varios países, los más importantes de la organización, propusimos a Eugenio y salió Eugenio de secretario general y estuvo bastantes años.
Eugenio Fernández Cabaleiro era una persona muy afable y siempre nuestras relaciones fueron muy buenas.
Os congressos funcionaram sempre bastante bem e foram até, digamos, motivo de conhecimento recíproco entre as várias nações participantes, que foram crescendo de congresso para congresso.
Estos congresos nos permiten ver de qué manera los países vamos confrontando los mismos problemas y de qué manera, en particular, cada uno de nosotros elaboramos una norma jurídica que permite combatirlos.
There is a huge diversity of the land registry systems, even if we talk about Europe, but when we enlarge the context, we notice that the differences are very relevant.
É importante que exista esse intercâmbio de conhecimento com os meus colegas, porque a linguagem é a mesma, os conceitos são os mesmos.
La existencia del CINDER como un centro de investigación genera también una convocatoria a otros científicos, a otros estudiosos, a otros profesores. Y así se va desarrollando la ciencia a través de la obra escrita, de la transmisión de la obra escrita a través de la docencia y de los diferentes sistemas en el mundo.
Cada país tiene su idiosincrasia y sus circunstancias. De hecho, a veces hay una tentación de creer que nuestro sistema es el mejor. Lo que en un país funciona muy bien, en otro a lo mejor no funcionaría.
Los acontecimientos importantes internacionales necesariamente tienen que afectar a una situación que está en el mundo real.
La provincia rusa de Moscú nos invitó al CINDER a hacer una visita a Moscú, a que les contáramos en qué consistía el registro y a ver si los rusos se sentían en condiciones de montar una situación parecida.
Os russos queriam criar todo um mercado hipotecário e a tecnologia jurídica que permitiria a criação de um sistema de segurança jurídica fue levada pelo CINDER.
Se pusieron en marcha los registros de la propiedad. Les hacían colas que daban la vuelta a la manzana porque ese papel les daba la sensación de ciudadanía que no tenían bajo el régimen comunista llevado hasta sus últimos extremos.
Rusia fue un momento apasionante, era un momento nuevo de creación, de ver cómo se implanta un registro.
Tuvo mucha importancia para el CINDER como tal, en tanto que nos permitió una expansión y nos abrió a un mundo, y por otro lado nos enseñó mucho porque fuera una cosa absolutamente nueva.
En algunos países del mundo, y es obvio, y hay que decirlo así, la independencia del registrador está bajo mínimos porque sufren presiones de todo tipo.
Nosotros tuvimos, hará unos 10 o 12 años atrás, una situación en la cual, por una ley, pretendían fusionar el registro con otro ente. Eso verdaderamente violentaba, digamos, nuestra independencia, nuestra autonomía institucional. Y yo recuerdo haber hablado con quien estaba al frente en ese momento del CINDER, del Colegio de Registradores de España. Emitieron un dictamen que luego yo hice llegar al Congreso Nacional de mi país. y esa ley fue parada.
Se ha solicitado el auxilio y en la medida posible se ha suministrado, generalmente por vía de argumentación. Y en ocasiones la argumentación ha sido acogida y dice, miren ustedes, como sigan por esa vía, el registro va a perder su valor.
Fue sumamente importante, marcó un hito, hasta eso ha llegado la colaboración que me han prestado.
Entre todos tratamos de protegernos y tratamos de aportar al fin último, que es mantener los sistemas registrales como tiene que ser.
Encontramos pessoas de outros países, com outras experiências, com outra formação, com outra orientação. Isto tudo fomenta o debate, tudo isto é muito criativo, é processo transformador.
You don't always have all the answers. So you constantly think how it can be done from one point to another, and you collect those small ideas from different conferences and from different countries.
En el CINDER de Dubái, a mí me llamó mucho la atención la exposición de Don Ikmar Bali sobre su proceso de modernización.
Transition of the registries, as long as I've been here, it has been moving from the paper to the digital, and there's many different steps that you need to do in this transition.
Los países latinoamericanos desde hace mucho tiempo estamos incorporando tecnología a los registros de propiedad, pero la forma en que lo ha hecho Estonia resulta muy inspirador porque se parece mucho al camino que hemos llevado en Latinoamérica, donde primero comenzamos con la captura de imágenes de los registros, es decir, para tratar de hacer ese tránsito de registros en soporte papel a registros en soporte electrónico, y luego ofrecer los servicios directamente.
Bizde bir laf vardır, tapu gibi sağlam diye bir deyim vardır Türkiye'de diye ifade edilir. Bir şey satın alınırken veya bir hak ifade edilirken biz bu sağlamlığı teknolojiyle mutlaka buluşturmamız gerekiyor. Güncel teknolojiyi takip etmemiz gerekiyor.
But those small things that you pick up from different countries that makes you and your story a bit better.
Para mí, como la satisfacción de haber sido secretario general durante esos 8 años, pues bueno, me permitió conocer por dentro los países y a mucha gente, muy buena gente y muy preparada.
Os congressos formaram muitos amigos, entre si formaram, sem dúvida nenhuma.
You don't see one another very often, but once we are here, it's like meeting your family again.
São relações de amizade que seguem, são duradouras, são estáveis.
Nos va a permitir ver cuáles son nuestras diferencias y cuáles son nuestras similitudes. Y en función de esto, poder hacer una aproximación o elaborar una política pública.
Espacios como CINDER son vitales, son fundamentales.
Somos algo más. Es la organización que representa a más registradores. CINDER tenía que ser el interlocutor de los registros ante los organismos multilaterales y los organismos de carácter mundial, como por ejemplo Banco Mundial o algunas organizaciones de carácter internacional.
El Banco Mundial al principio estaba como receloso del sistema nuestro, pero después fue aceptando el sistema y de acuerdo con el sistema, por eso ha ido a exponer a distintas partes.
La última vez que CINDER estuvo presente en el Banco Mundial, en la conferencia en Washington, sí se puso de manifiesto por parte de las autoridades del Banco Mundial la necesidad imprescindible de que todos estos países a los que el Banco Mundial está prestando asistencia tengan un registro de titularidades, un registro de la propiedad, para poder garantizar la certeza y la finalidad del dinero que se invierte, porque es que si no se malversa y todo el dinero que se da con buena voluntad para cooperación y desarrollo puede acabar, así sucede, en manos de desalmados que le dan un destino diferente.
Pero luego viene también la fase de China. China piden que el CINDER les ayude y piden asesoramiento y piden participar y piden incluso organizar un congreso.
Por lo menos ha aportado soluciones que luego, ya digo, que no se calcan en ningún lugar, pero sí ha permitido que la gente que está en los sitios vaya ideando e pensando cosas e creo que en general se está avanzando.
Os congressos do CINDER sempre procuraram temas atuais e que abrissem portas para o futuro e que nos mostrassem o que é que o futuro nos traz.
Holanda sería el Congreso del Cambio y precisamente los temas del Congreso, uno de ellos va a ser todo el aspecto de las ejecuciones hipotecarias y todos sus efectos fruto de la correspondiente crisis económica.
A crise das hipotecas, né, repercutiu na nossa área de uma maneira muito positiva, porque pudemos enxergar aquele fenômeno de uma perspectiva privilegiada. E neste congresso do CINDER, Nicolás Nogueiroles fez uma retrospectiva de todo o desenvolvimento do sistema de segurança das transações jurídicas nos Estados Unidos e pôde demonstrar como o sistema de registro de direitos em vários aspectos é superior àquelas soluções apresentadas pelo mercado ou pelas instituições financeiras.
Se fueron produciendo una serie de sucesivos aplazamientos y no se veía el final del túnel. De suerte que cuando pusimos la última fecha, que fue la de su verdadera celebración, no teníamos tampoco la certeza de que pudiéramos organizarlo convenientemente.
Estaba la tentación de hacer un congreso virtual, pero decidimos que no. El poder hablar, el poder desarrollar y el verse cara a cara siempre es mucho mejor.
Gracias a Dios la epidemia fue remitiendo y se permitió celebrar el congreso.
No es lo mismo poder compartir durante un tiempo en una cámara que poder verte, darte un abrazo y compartir información. Se vuelve más personal y con una taza de café, ojalá de Costa Rica, pues fluyen más las ideas y fluye más ese compartir.
The Congress is looking at people, talking with people, explaining things, and that's online, that's a whole different thing, where I believe that you need to see people.
You need to sometimes go in depth. So what is quite nice is afterwards there are colleagues who will approach and say, can you explain something to me that you have said that you didn't have time in your presentation?
Porque además hay una parte también lúdica que hace que la gente se relaje, que no olvidemos lo académico, pero que seamos nosotros mismos.
La parte íntima, lo que a veces no se tiene que decir de manera formal, lo decimos en los cafés y es muy valioso. Porque es decirte, esa empresa no funciona para lo que estás haciendo y tal, nos han quedado mal, este te va a salir más caro, más barato que el otro, eso se comparte en los cafés, es muy valioso.
Para nosotros va a seguir siendo ese referente necesario en esta materia que tanto queremos y nos apasiona, que es el registro.
Cosas que nosotros pensábamos que eran de carácter natural, descubrimos en otros países los motivos, las razones.
Da uma espécie de cultura comum.
Todos queremos sempre viver num mundo melhor, não é? E nós achamos que o nosso papel do dia a dia, do trabalho que se faz, que tem um pouco essa função, um bocadinho aqui, um pouco ali, um pouco lá.
Al final nos damos cuenta que sea el sistema registral que tengan nuestros países, nuestros problemas siguen siendo los mismos.
O registro predial é registro predial e quem conhece consegue se comunicar com qualquer uma nacionalidade.
Voltamos para os nossos países con novas ideas.
Siempre es enriquecedor y siempre mejoras, aprendiendo cosas que otros hacen y dices, bueno, pues a ver, si esto yo lo pongo en práctica, en España, ¿qué ocurriría?
A mí me gustaría que tuviera una cobertura, por soñar, casi universal.
El futuro es precioso, porque hay mucho por construir, todavía quedan muchísimas cosas por hacer.
Más que CINDER, pues CINDER también es un instrumento. Está al servicio de los registros y eso es a su vez al servicio de los ciudadanos. Que los registros fueran cada vez más eficientes y más justos.
Bueno, después del vídeo ya hay poco más que añadir.
Well, there is not much to add after this video, so I'd like to give the floor to Alfonso Candao, General Secretary, so that he can close. Thank you.
Ahora no os preocupéis, two things. First of all, we have a little cocktail here outside, and the Congress is over. Thank you very much.